Well, good morning, Travis. Walter, how is it going in sunny Texas this morning?
It's going great from both counties, Travis
Yeah.
and Williamson County, two counties.
Yes.
It's a beautiful day. We had rain come through. We're supposed to have a tropical storm hit maybe Wednesday, the remnant.
Wow.
It's 73 degrees right now, sunny, not a cloud in the sky. So it's really good. Nice, relaxing day. And when I heard you wanted to do this, I thought there's no better way to spend a Sunday morning than with my good friend from Scotland. So
Except I'm in Williamson County at the moment.
Yeah.
In fact, I'm a little bit confused to do with obviously the documentary Outcry. The first thing is Leander, the town or the city, is quoted as being in Travis and Williamson County. Is it sort of, does the border go through the middle of it or something?
Yeah. So that does to the everyone wants the tax base, and so half of it's in Williamson County and in Travis. And then if you live in the city limits, of course. And then there's a school district, which is also confusing, the Leander Independent School District, LISD. They have 5 high schools. My son goes to one of the high schools in that district. And so that's another plot that lays on the grid that's a taxing authority. And that covers Williamson and Travis County, but it covers the cities of Leander, Cedar Park, Round Rock, and so it overlaps. And that's just how they do things in the states. On school districts, they kind of cover an area that makes sense in terms of the number of students. And so if that needs to cover just one county or one city, like AISD, Austin Independent School District's pretty much the city limits. But yeah, so it lays over. In terms of who had jurisdiction of anything that happened, any crime that occurred in either the city of Cedar Park or the city of Leander, that would all be the Williamson County District Attorney's Office.
Mm-hmm. Lovely. So really, I suppose the next point I was going to make was, wow, what an interesting documentary, and credit to you for pointing it out to me and the dude. I think a while back was when you first mentioned.
Yeah. So I had some involvement in that case after the trial. And so I'm limited to some things I can discuss, but I didn't have a direct party. I had a client that had interest in the appeal afterwards, the writ, the motion for post-conviction relief. But we knew they were filming a documentary as the case was proceeding. I know everybody involved in the case really, really well. Everybody.
Yeah.
And so we knew one was happening, and then from people that were involved in the case, I was advised it was going to go live on Showtime on July 5th here in the United States. I started talking to you and Richard about it in early to mid-June, and I said, you really need to watch this 5-part series for a couple of reasons, and we'll get into those.
Yep. My sort of having watched it, not just once, watched it through, I think, to episode 2. Then I started rewatching it from the beginning with Eunice watching, and I've been back to it again. It seems like a bit like so many of these cases. At times, I'm kind of struggling to see, normally you've got, the good guys and the bad guys. But in this one, there seem to be some pretty blurred lines on this,
Oh, yeah, most definitely. There's gray areas on what constitutes ineffective assistance of counsel. They're about whether a inadequate or negligent investigation can constitute violation of constitutional rights. There's no law on that. Really, the overarching thing that kind of gets lost in the documentary, I thought, is what an outcry is. And, we should probably talk about that now or whatever. But, what an outcry is normally if I shoot you in the parking lot of a bowling alley and you die and Donnie sees me shoot Smokey. And he can describe that and testify what he perceives in court. But if Donnie calls his friends and tells them what happens and then gets upset and anxiety and dies of a heart attack in the same bowling alley parking lot, his verbal statements are not admissible. They're hearsay, just ranked hearsay. And to get hearsay in, there has to be an exception. So years and years ago, 30, 40 years ago, prosecutors were frustrated that small children, 4, 5, 6, 7, who there was pretty good evidence some sort of abuse was going on. But, abuse always is one-on-one and secret in the dark. It's not something typically that there would ever be a witness to. And so they created this exception on children with sexual molestation. And the law is that an adult over 18, the first person that a child makes an outcry to, that adult can get on the stand and testifies to what the child told him. And so the effect on the jury is they're getting the story from an adult. It's like a proxy. And then you can even have multiple outcry witnesses if it's a different victim. Another adult can come into court and say, child B told me this happened to him or her. If they reveal information not contained in an initial outcry, that they remembered more, you can bring that person. So what ends up happening at trial on these cases is that typically the child says something to a parent, and this person did this to me and this happened, and they call the police and they send out an officer to take an initial report. They talk to the child just briefly what happened. So there's an outcry. So now you have 2 outcries. And then the protocol now, ever since McMartin, the LA case, is to bring them to a child advocacy center, a CAC. Who's our friend that works at one of those? One of your viewers is, who do we know that actually does that?
Yes, the lady that's been on with the dude a couple of times.
Is it Zany?
I thought it was a Spanish Mexican name. I will look her up because
anyway, we need to get her. We need to get her on your show.
Anyway. Yeah, I've actually spoken to Eunice about because she works in a nursery. What would happen if a child came forward to her and said, something similar to what had happened, and she would immediately get in touch with somebody that she has to then interview that. So yeah, it's the same system over here. Yeah.
So we have a really good CAC
Yep.
in Williamson County, and a CAC, what they do is they set up an appointment, and you have a forensically trained interviewer that's trained not to ask any leading questions, not to suggest any answers.
Sure.
And they're all trained to start off with, why are you here today? And you see some of these clips in Outcry, but they don't give a lot of context to it. But they'll say, why are you here today? And sometimes they'll say, because of Greg, or because of what my stepdad did to me, or, and sometimes they say nothing, and they're trained, to not suggest anything, but try and get the conversation over to, did something happen to you? Because you don't want to suggest anything with children that age. I don't know, was it surprising to you at all that somebody could be charged and convicted on the word of a 4-year-old?
Not really. I mean, I've seen, I've seen, I would have to say, too many of these documentaries nowadays to be shocked by anything. The number of people that I see that I think to myself, they found this person guilty. Have they proven beyond a reasonable doubt? And I'd have to say, absolutely no way. I mean, certainly, when during the interview of the young lad, he came out with stuff that, as everybody pointed out, it's not the sort of thing that a 4-year-old should be coming out with. And I know that the one sort of the lead guilter, if you like, that's interviewed is a Lindsay Armstrong, who went to the same school as Greg Kelly. Yeah, and I found her to almost take it personally, that there was this suggestion that maybe the child, it didn't really happen to the child. Certainly the second charge, there was another child came forward after they'd advertised, could somebody else come forward and help back up this case. I didn't feel much warmth towards Lindsay. I feel sorry for the fact that she was a victim, but the fact that she was taking it so personally, I didn't care for that very much. I want to take you back though. At the very start of Outcry, we're introduced to the fact, of course, that the Michael Morton case occurred in the same area. Yeah, and that's our friend.
It occurred about 15 miles east in city, right near where the courthouse is in Williamson County, over near Georgetown. Yeah.
And the sheriff responsible for arresting Michael Morton, and this I think was something that was very interesting when they asked Officer Daly, Inspector Daly, Detective Daly, what is the goal of an investigation? And he said to secure a conviction. And I found that to be quite a blurring of the lines as to what the job of the police is versus what is the job of the attorney. Now, in the introduction to in the beginning of Outcry, they mentioned the Michael Morton case, and who was it? The attorney at that time was Ken Anderson. So he came in for criticism.
The prosecutor, yeah,
but really it was Jim Boutwell, who is famously in the Confession Killer, isn't he?
Yes.
So I'm a bit lost as to who's really to blame for this wrongful conviction. Is it the attorney once he's been given the stuff by the police and decides to run with it?
Anderson. So Michael Morton case and the case that was depicted in Outcry apples and oranges. Why that case went off the rails, Michael Morton, is at the time Ken Anderson was the DA,
Yeah.
and had a couple of assistants working with him, and the judge ordered them to turn over everything in the file.
Mm-hmm.
And what came out later on, after Michael spent years and years and years in prison for
Mm-hmm.
something he didn't do, was that two things. The DA determined that a statement of the young boy, who was 3 or 4, described his mother's attacker and said it wasn't daddy.
Yep.
And then also there was a bandana with blood on it and DNA, who came back to the real killer.
Yes.
I can't recall if he committed other crimes, but I think he did. But it was pretty well established that Ken Anderson buried that information on purpose. When things started rolling and they were trying to do agreement to just double check everything, Ken Anderson had become a district court judge, and his second in command became DA.
Right.
And, with a lot of influence and pushing by Judge Anderson, they fought tooth and nail to have anything DNA tested.
Yep.
And, it just took years.
Mm-hmm.
And because I think they knew what the result was going to be. And so, but the Michael Morton case is some of the most outrageous, egregious conduct, as evidenced by Ken Anderson had to resign from the bench. He was disbarred by the Texas bar.
Wow.
Because so much time had elapsed, the only thing that they could do to him was convene what they call a court of inquiry.
Right.
And so he did do a little bit of jail time, but you know how unheard of that is. Yeah. But, he did very, very little, but it's because so much time had passed. But the fact that he even did any jail time at all is pretty rare in the United States because of prosecutorial immunity.
I was going to say, it kind of strikes me a bit like in America you call it soccer, but over here we have football. And if you have a game that's played and there is a decision made during the game, which means that really the wrong result of the game was achieved, the result still stands. And that seems to be the sort of ideology, is that the right word, of a lot of these prosecutors, that once they've won in court, that should be it. That's, there shouldn't be any going back on that at all. The result should stand. And I mean, I suppose, using the football analogy isn't a good example, because there, as I say, the result does stand because of the knock-on effect of all the other teams in the league. Yeah. But when it comes to
and sporting events and jury trials, got to have finality. Mm-hmm. There was an Indianapolis 500 with Mario Andretti. Wow. And one of the unsers, Bobby, and a rule that was a gray area about if you could pass when you came out of the pits. And that thing, it went back, it got into the courts and went back and forth. And, so, and they still kid each other to this day about, who won that race. And Andretti says, hey, a rule's a rule. And Unser was, but you want finality. It's why these victim integrity, the conviction integrity units are so massively important that you get a person in that works with the DA's office, but is going to work with post-conviction counsel on determining if there's really something here to pursue and kind of streamline it. Because, and the other side of it is, I wish we could get some statistics, and we never will, I don't think, but how many applications go into like a Texas Innocence Project or a Wisconsin Innocence Project? That person says, I'm innocent, I'm innocent, I'm innocent. And we know it happened to Zellner at least once, but they start to look into it through their screening criteria and maybe even get to the point where they test something and, it's crystal clear that the person was guilty. I would suspect that because there are so many applications and they're able to take so few, I would suspect that the numbers coming in of prisoners is quite high, that really there's no chance, whether that's because there's solid evidence that shows they were the real perpetrator, or maybe there's no DNA. But there are a lot of people that try and get post-conviction relief, and that's where this finality came up. And in the early 60s, the U.S. Supreme Court laid down a lot of rules of procedure that gave people who were convicted a lot of different options and avenues to get a new trial. And starting in about 65, both parties have been campaigning on a get tough and crime and that whole thing. And those things have been whittled away, either by one party or the other, or EDPA was a bipartisan effort.
Yeah. The thing is, after Ken Anderson, you then had was it Jana Duty, who then became the DA.
She ran against. So Ken Anderson went to the bench. His first assistant became district attorney.
Was that John Bradley?
No.
No, I've got some of it down to John Bradley.
I'll give it in a minute. But Jana Duty ran against him in the aftermath of Michael Morton.
Yes.
About how egregious that office was, and that they continued despite knowing that he might be innocent. She ran on those issues, and Bradley was the successor to Anderson.
Yeah,
and she ran against him. She was the county attorney at the time. She beat him, and then her office handled the prosecution of the case and that covered in the outcry.
Yeah. And then she was then. Oh, cheerio! Daughter's taking the dog away.
Cheerio!
Peace and quiet.
Let's see the dog.
Oh, he's gone. But he's the one that you often see when I've taken out for a walk. The black collie, the border collie called Nap. And then Jana Duty. Yeah. She was eventually replaced. Was it as a result of the again the Greg Kelly outcry? Was that what really did for her?
So not the documentary, but the case.
No. Yeah.
That case did, and the outcry shows this one supporter who's able to get people organized.
Yeah.
And then Greg Kelly's appellate attorney, post-conviction attorney, Keith Hampton, who's an excellent lawyer. He's a good friend of mine, dedicated to criminal defense his entire career. And he tries to go and have just a sit down, an informal meeting. And in outcry, he just says, you know, I had a 30-minute presentation prepared or whatnot, and you know, I didn't get 5 minutes into it, and you know, they just shut him down. Yeah. And they so the support group got together, and one Patricia Cummings had put them in touch with Keith Hampton, because Keith Hampton is really, really good in post-conviction, and got that rolling. And then this opportunity came up with an election of Deanna Duty, and Sean Dick was interested in running. And as often happens, they got organized and got money and support for him, and went out and campaigned for him by YouTube, door to door, raising money for Sean Dick. And because, you know, he apparently said, look, if I'm elected, I will keep an open mind, and I'll look at this. I don't know what all, you know, was agreed to or that, but soon after the election, Sean Dick and the writ, they started scheduling for the evidentiary hearing.
Yeah. It's the guy was called Jake Brydon, wasn't he? And he was referred to, I thought it's quite funny, as the mouth of the South.
Yeah, that's for sure. He definitely. Sorry about that.
No, same as my daughter coming in to collect the dog. It's actually quite good at times to see that we are normal people that live in normal houses, and there's normal people going around doing normal everyday things.
Well, yeah, he's got to let the whole neighborhood know that who's in charge around here. So once everybody's been alerted, then he's fine.
Yeah.
But that's one of the things I wanted your group of supporters and Avery supporters to understand and see is on the non-legal side, what you can achieve with, you know, the right support and the political aspect of it.
Yeah.
And that's what I was talking with Richard about leading up, going into July, was that, you know, not so much the case. It's, you know, it's pretty typical wrongful conviction case. There's no, you know, evidence of planting. There's no evidence that anyone withheld any evidence. You know, but you try and make a documentary interesting, and so, you know, you present it a certain way, and I think they did a wonderful job of that. But there's a lot on the other side that you don't see in the documentary, but that's fine. Anything that gets people interested in these issues is good. But the way that supporter, and you saw the numbers that they had in the high school parking lot, that they had in front of the courthouse for every hearing, getting the DA elected, or helping to get the DA elected, pressuring the police department as to what was going on and whatnot. And that's what I really wanted supporters to see, is how you can make a change. And people were part of that support group, largely within either Williamson or Travis County, but from all over the United States. And so there's some interesting things to consider, how it parallels with Stephen.
Yeah.
Greg Kelly's high school football star in Texas. That's a big deal. And they try and capture the flavor of that. It's high school football, Friday Night Lights is a big, big deal in Texas. And so you had a popular kid, had his whole life ahead of him and dreams about going on to college football. And so he had a lot of people in his corner before any documentary. So that's another thing to keep in mind. The support didn't come after the documentary.
No.
How long did the producers work on Steve? Was it 10 years they worked on the documentary?
Well, yes. Yeah, absolutely.
And so Greg Kelly was actually given his exoneration by the Court of Criminal Appeals during the filming of Outcry, and you see that happen.
Yep.
And then he was declared innocent in the district court. That's our procedure here. But he had a groundswell of support right from the get-go, and it's been talked about, because of the way people see or saw the Averys and that sort of thing. But there are a lot of lessons, I think, that can be drawn from the leader of that support group and what they did. That'll help in Stephen's case.
Yes, I think absolutely the consensus of opinion of certainly people at the rally last year and the year before was that within Manitowoc there is support for Stephen Brydon, but it's not vocal at the moment because obviously fear of reprisal, and that eventually will hopefully change.
But the reprisal of who? I'm wondering.
Yeah.
I'm wondering who fears reprisal. What needs to happen with Brydon's case is figuring out a way. They came from all over the United States to be on the courthouse steps and the Capitol steps in Little Rock, Arkansas, for the West Memphis Three. And there needs to be a coordinated event with 400 or 500 people on the Capitol steps in Madison.
Mm-hmm. Yeah.
And of course, in these times, that's not going to happen. So, until there's a vaccine or whatever it is, that we can get back more to normal. But that's the type of thing that needs to happen, is when the legislature is in session, you have a significant turnout of people that's focused.
I wanted to touch on a little bit, and I don't know how much you'll be able to say about this, because obviously you know all the most of the people involved. One thing that was definitely touched on in the documentary was Patricia Cummings, her conflict of interest, and even Sean Dick's attorneys were sort of having a go at her about this conflict of interest and ineffective assistance of counsel. Is a conflict of interest an example of ineffective assistance of counsel?
It can be,
Right.
most certainly. It can be, and especially if it's not disclosed. So, if the the clear case would be if when I come and visit you in Scotland and we rent a car, and if we were pulled over and they asked to look in the trunk. What do you call a trunk in Scotland?
The boot.
The boot.
The boot.
So if they asked to look in the boot, and we say, yeah, we got no problems with that, and they open up the boot and there's a kilo of cocaine in there, you're obviously going to be saying, well, he just picked me up. I don't know anything about it. I'm going to be saying, well, must have been the last guy that rented the car. There's a conflict with one lawyer representing both of us, because you need to be able to argue, look, all I know is he rented the car. It's his car. He picked me up. I don't know what was in there before. I don't know what he put in there. All I know is it wasn't me. He could have. Yeah, there was times I wasn't around when he was loading the boot of the car, what have you. But that's a clear conflict. So where they said the conflict was in this case is that Patricia had represented one of the daycare operator's son in the past, and then they made the referral to Ray Kelly's family to get a hold of Patricia, and they were trying to say, and Patricia was really good friends with Sharma.
Yeah.
She's just a real piece of work. And that because of that, they didn't look at this similarity defense. But, and that was a conflict. The Court of Criminal Appeals came out, and what they typically do when they grant a petition for post-conviction relief after evidentiary hearings, the district court judge makes recommendation. Says, I recommend that this be reversed and he be found actually innocent because of this. And she listed ineffective assistance of counsel, the new evidence about where he was GPS wise, and so on and so forth. And she listed 4 or 5 reasons. And then the order says, we've read the writ and we hereby grant it. That's it. Doesn't explain the reasoning. But 2 judges felt compelled to write an opinion discussing 2 issues, the ineffective assistance of counsel and whether the investigation somehow implicated constitutional rights or not. And that opinion's very, very detailed, 70 or 80 pages, and explains why under Texas law it wasn't they agree with the decision that he be found actually innocent, that go to district court, that the case be over and done with, and he can be found innocent by the district court. They agreed with the reasoning, but they specified why they saw no ineffective assistance of counsel and why they didn't think the investigation or lack thereof implicated any constitutional violation. Why they did that is the positions advocated in the writ for post-conviction relief would have had a significant impact on other cases pending, previous law on conflict of interest, and Texas really does have a very liberal, in the sense that it's not a strict construction, that a public defender, for example, can represent a client charged with murder and then deal with that case, and then later on represent somebody that's a family member of the victim of the murder. And they just have, and so people have brought ineffective assistance of counsel based on conflict of interest, and they've said, no, that's not a conflict. And when I've read those opinions, I went, wow, that's, I personally would never even have the conversation with the family. I'd say, hey, I need you to know that I represented the guy who was accused of killing your uncle, brother, son, father, and I just wouldn't be comfortable representing you in it. But so that part of it, pretty thin, but Keith developed really, really good, solid evidentiary basis for actual innocence. Just that the timing. Now, see, the most egregious thing I felt was, they have this outcry that the child tells one of his parents, Greg did this. And I can't remember the exact dates. If you have them in front of you, correct me. But, let's just pick a date, July 15th.
Yeah. That's right.
Pardon?
I'm going to say that there was a bit of vagueness over the date as time wore on, wasn't there? Yeah.
Yeah. So they, when did this happen? He broke his arm at the daycare. This thing came out. But the officer's opinion was, well, it's kind of, in this 1 or 2 week gap. But then all of the child advocacy people, the forensic interviewers, which is why I'd love to have the supporter who does that here in the U.S. come on and talk about that. Children at 3 or 4 years of age don't have this concept of time. And so they moved the date because that date that was initially put in the report, Greg had moved out of the house.
Yes.
But it's common in cases involving children that they'll start with a date and then they'll make a window, which they're constitutionally allowed to do in Texas.
Sure.
They can use this huge window of time. And then at trial, the prosecutors, and they covered this, I think, in the last episode of Outcry, the prosecutors built their whole case on this date in June when Greg was still living at the house. And that's got nothing to do with the police. It's got nothing to do with ineffective assistance of counsel. It has to do with how the prosecutor is going to paint his or her narrative. And then, but with those types of cases, it's not like Stephen Avery's case where the prosecutors painted a narrative that it had to fit a certain way, like burn bones in the court. With this, they're able to say, well, children 3, 4, they don't know last week from last year, so.
Sure. After I ask you this one, we obviously hear in Making a Murderer about the fact that Dean and Jerry are almost welcoming of the opportunity to be sort of put on a stand and to be asked about their ineffective assistance of counsel. In fact, Jerry, as I said cheerio to him in Amsterdam, I mentioned to him, I said, any chance you want to come on and have a chat with Eric Jose? Which he declined. But in his email to me, most recent one, he said, about the dude, he said, maybe I wish I had have accepted the invitation. But the point was, he said, I have to be careful what I say because I could be facing an evidentiary hearing to do with ineffective assistance of counsel. But it's almost as if they are looking forward to that opportunity. Is it something that most lawyers would not like on their record, that they had they were for want of a better word, found guilty of ineffective assistance of counsel, or is it something that some do and some don't? I'm a bit confused, because I got the sense that Patricia Cummings definitely did not want any suggestion of ineffective assistance of counsel.
I think she didn't want any suggestion of ineffective assistance of counsel on the basis that Keith was going with. So right. To analogize it in the Stephen Avery case, if people are going to be real familiar with the fact, both Jerry and Dean have given affidavits that give an opening to ineffective assistance of counsel. The affidavit says, I cannot think of a legal or strategic reason for not doing X, which is, let's say, hiring a blood spatter expert.
Yeah.
That gives an opening at an evidentiary hearing for them to, they can't give a conclusory affidavit and say I was ineffective. They just need to give the opening of it, and then Kathleen develops that at an evidentiary hearing. And so, but if if the allegation was that they were ineffective because they liked Brydon better than me, I don't know,
sure.
Just something off the wall, and they're, they would not agree with that. They're going to say it didn't happen and this didn't happen. And so usually the way that works is, you heard Dean Strang say it, that there was initially a letter that Stephen sent to the media.
Yeah.
And pretty upsetting letter. And then Jerry and Dean responded to that in public in a classy, appropriate way. And they didn't get personal about it. And they knew that they didn't want to impact his post-conviction case. And so they gave a reply that wouldn't hurt that, although they very well could have. They left it open. And so, but normally what happens is there's meetings between the post-conviction counsel and the trial counsel, and you're just asked questions. Can you think of a reason why you didn't do this? Can you think of a reason why you didn't do that? So there's an affidavit. I can't remember. I don't have it handy. There's 30,000 pages in this record. I've read every single page, plus transcripts. Some of it's still sealed, but there was a third lawyer. There were two lawyers helping Patricia, and one of those lawyers had to get off the case because other cases and stuff came in, but they got an affidavit from him. And about these questions, why didn't you pursue the similarity of appearance defense, ID confusion defense, versus just pursuing, we think the child's just memory is bad. It never happened at that house, and he's just confused. It couldn't have happened at that house, which is what the ultimate defense was. And that attorney said, well, we never came up with that. When I personally met with Mr. Kelly in jail, and I personally met with him in the office and with Patricia. I can't remember the details, but I remember him saying this and that. There was never any, it wasn't considered because it was never a viable option based on what I heard Greg Kelly say to me. And so because of how this happened procedurally, and I won't get bogged down in all of that, because the way it happened procedurally, with, okay, well, Patricia, was going to respond to some of these allegations, which were by the supporter group, not Keith Hampton, but the stuff coming out in the supporter group on Facebook and social media. This can be the downside of supporters. It was like, well, no, I'm going to address these accusations about this or that. They don't impact his chance at getting a reversal based on IAC. It's just all this extraneous stuff out there. So then Keith, talking about the chess moves we all make procedurally, says, okay, I'm going to have no questions and I'm not going to waive attorney-client privilege. And then the state's going to talk about conflict of interest. But the opinion that came out said, there's been a whole bunch about this. I'm sorry, but not a conflict of interest. But there are other issues that have merit. And so something turned things contentious. And, one thing about that support group is he was kind of in your face, and he, is the type of guy that said, here's the address and phone number of his former attorney. Now, he tried that when we started, getting the amicus briefs filed, and not one amicus brief said that the case should not be reversed. The amicus briefs were, no, you're wrong about the investigation. No, you're wrong about ineffective assistance of counsel. No, you're wrong about there wasn't really a contested evidentiary hearing on certain issues. But he put out there that, here's the address, phone numbers of the attorneys filing these amicus briefs for the detective, for Patricia Cummings, for all the various groups that filed amicus briefs. And that thing that he put up on Facebook was immediately shared and given right back to the Court of Criminal Appeals. And then I forwarded it to certain people. And within a couple of hours, he took that post down and said, apparently my post upset some people, but there's kind of this gonzo tactics, I'll call them, from Hunter S. Thompson, but that only flies so far when you have a pending case. You don't do that stuff. You'll get you'll get a Texas Ranger knocking at your door. You'll get an FBI agent knocking at your door. It's regardless of what an attorney's position is that they're advocating. You just never want a situation where an advocate is attacked merely for presenting a petition. Because I'll tell you, 99% of the time, and I've seen the most faithful Stephen Avery and Brendan Dassey supporters be on other channels about other cases where children have been abducted, tortured, or missing, and they're convicted within 1 day of the arrest, and there needs to be lawyers defending them without fear of threats or comments, anything like that. But so I think I can't say for sure. Patricia Cummings is a good friend of mine. I could tell you this: there's nobody more dedicated to wrongful convictions, false confessions than her anywhere else in the United States. After that, she was a key part of the Michael Morton defense team. Then she had that case, and just got a lot of nasty mail and nasty comments and social media. And then he was given the opportunity to be a conviction integrity unit attorney up in Dallas and transform that office. And then later on, she's gone to Philadelphia and is the the conviction integrity unit lawyer in Philadelphia, and has been doing such a good job. She got 3 or 4 people out of prison as part of the innocence files, covered one case. Now they're getting so much pushback that the judges are saying, "Well, we'll wait." Okay, so the DA agrees, defense attorney agrees. There's all of this evidence.
Yeah,
I'm not going to do it. And I think she's had 9 black defendants she's petitioned for. Got 4 or 5 of those in combination with the defense attorney.
sure.
Released and exonerated, but now it's getting to the point the judges are just pushing back because the police unions are saying, no, this guy's guilty. We know it's guilty, so we're back to confirmatory bias.
Yeah.
And the judges don't want to be perceived as being weak on crime. That's still a substantial problem in this country. And it's a problem when high school football star, good looking, that there's a massive movement of support versus somebody who may be of color from a lower socioeconomic background.
Sure.
And we have a lot of work to do over here yet.
Sure. One final question, because I've kept you long enough. To do with evidentiary hearings, obviously we're hoping that the District 2 of the Wisconsin Court of Appeals will have an evidentiary hearing. And it was a comment by Mark Hodinut when I did a live chat with him on, it was either Wednesday or Thursday morning. It was one morning anyway. And he said he's looking forward to, Karen Holbach taking the stand and Kathleen Zellner saying, these bones that were handed back, do you believe that they are Teresa's? And then obviously the follow up to that would be, depending on what her answer is, well, yes or no. If she says yes, fine. Are you aware of the fact that those bones were not the ones that were found behind Stephen Avery's garage? They were found over a mile away. And of course, if she, if she says, do you believe that they are your daughters? If she says no, well, I think this is going to be quite an interesting. Is that the sort of thing that Kathleen Zellner is hoping at some point to do in the future?
I don't think it's with the family. If she can get the answer with the Whiting Funeral Home,
sure,
what happened to the bones,
right,
and she only needs to know in order to make her arguments after
right,
all of the evidence comes in the evidentiary hearing, are those still available to be tested?
right.
And either, Whiting says, yeah, they never picked them up, we still have them, or
Sure.
they never picked them up and we disposed of them, or yeah, I personally gave these to this person, the family.
Sure.
Are you aware of what was done with that? Yeah, we helped them with a burial, or
Sure.
we did a cremation. And so only to the extent that they a trail of evidence needs to be established would. And so if nobody knew, Zellner, I am sure, would try to get that established from the AG's office and say, well, where are they? Our investigators talked to Whiting. They have no idea. So the only way we can get this figured into evidence is either call them, which we don't really want to do, or do a stipulation. And that would probably be worked out because the frame of mind, the what you were talking about, the mental state of mind, handing these objects to a Whiting Funeral Home for purposes of getting them to the family. It's the state of mind in what Fallon and Gahn and the evidence person and having Eisenberg's report and, okay, we want to return
Yes.
her remains to the family. That's the whole premise. And then at one point in time, these bones didn't deserve 20 seconds. Now all of a sudden, they deserve 3 of them, sorting them out on a table and carefully inventorying them and putting them in a box and getting them to the funeral home.
Yeah.
So it's more what viewing more on what Fallon, Gahn, and the evidence person in combination with Eisenberg's initial report, what their beliefs were. And it doesn't really matter what. Now, I said early on when we first broke that on Richard's YouTube channel in December, we kind of put the fact together that she was trying to test bones that had been returned to the family, and that's a spoliation issue, a Youngblood issue.
Yes.
And I'd mentioned at that time that it would be interesting to know what, if anything, they were told about, and the other thing I mentioned at the time was that, like in West Memphis 3, there are certain things that can cause a schism between the prosecutor's office, DA's office, AG's office, and the family. And that actually occurred in West Memphis 3, to where they did find out more and more, and they did find out more and more, to the point where they said, hang on a second, I have serious doubts about how this investigation may have been conducted. But that's because, the stepfather of the one boy turned out to be the perfect villain, and, DNA caught up. But there's a third family that believe that the three men, they have the right men, that, they're out of the public now, and moved on. They moved out of town, out of state. And, so that's just one of the things that happen when families are told. It happens with victims who are ID witnesses. We were going over yesterday on Millbilly's channel, or day before yesterday, the Penny Bernstein H5 sex assault case, and how at best they had this confirmatory bias hate for Stephen, and that sounds like Stephen, and then you get a rendition, and then, but you see that a lot in the innocent files. Their witnesses, ID witnesses, starting to have second thoughts, and they come in and, oh, it's natural, and we have so much evidence besides you, but basically trying to say, here's stuff to help you convince yourself you picked the right person the first time.
Sure.
And, it's the worst type of evidence there is ID evidence. It's just been proven over and over and over again, either because of the way we record things in our memory going through trauma, number one, or number two, the mechanisms and devices that police either unintentionally or intentionally use in ID techniques.
Yeah.
6 individuals in a lineup, 5 African American, 1 Caucasian.
Yeah.
They're kind of egregious stuff, but then it shades of gray from there. But yeah. You have any questions in the chat? I can't see it. Say hello to everybody.
Really, just obviously, as we know, there's quite a similarity between this Greg Kelly case and the Daniel Holtzclaw case. Not really much in the way of no questions, but well, hopefully we will get an evidentiary hearing in the Stephen Avery case pretty soon. And I know that
I think
a lot of people
I tracked some decisions, and it's extremely rare that that court, that particular appellate court, grants oral argument in criminal cases, but they did one last year. Right. Now that has the effect of delaying things normally, because scheduling the attorneys for the oral argument and whatnot. So if they do rule and say they're going to do an oral argument, I think we would probably have that ruling in a month, maybe 2 at the most. If they deny oral argument, I think we'll have a decision before the end of the year, whether they're going to be evidentiary hearing or not. If they grant oral argument, that could put it off to oral argument, towards the end of the year, and then a decision 2 to 4 months after that.
Right.
So, it's progressing.
Yes.
And it's, they They say that they look at each case as the order that they come in. That's pretty much true. We've been tracking that, even looking at cases since March. So despite the times that we're in with the pandemic, the court is continuing to function. They continue to issue decisions. They're doing their work. And unlike the trial courts, which are pretty much all shut down. And so even if there's it's heard and they said, no, the circuit court, you screwed it up. There needs to be evidentiary hearings on these issues. There's going to be delay on that. They'll maybe do some by Zoom. But those types of hearings, you really want to be in person because it's mainly cross-examination, the way Dellner does it.
Yeah.
He really wants to be in the same room, face to face with that person, getting them to explain these problems she sees with their narrative. Mm-hmm. And things she still, hasn't fully disclosed that she has documentary evidence on. I'm not talking about brand new stuff. I'm talking about stuff detailed that just doesn't go in her brief that would be questions following up on the issues in her brief. She didn't want to disclose everything that she's going to be just cross-examining on. She has to put every legal issue in her brief, but she doesn't have to put every question. Like, I want to bring in the family and ask, what were you told about the phone? I don't think, I think it's clear, and I think she even mentioned in her brief or her, either her appellate brief or her reply to the response, she wants to talk to Gone and Fallon and the evidence tech as to, why those particular bones.
Yeah. Well, listen, time has flown as usual.
So you have a minute to talk about the scheduling for next week, and it's next Saturday, right?
Next Saturday. All I know at the moment is that the church in that's holding the celebration. It's not really being called a funeral at all. I think it's simply being called a celebration. Kickoff time, as far as I know, is 1:30 Pacific time. And I do know that the Redeemer Covenant Church, where it's being held, they have a YouTube channel. So I think everybody will be able to choose. Once I've got some details, I'll certainly be making them sort of put in the details out there. But yes, it's.
I think I heard that they scheduled it at 1:30 Pacific.
Yeah,
to try and accommodate people in the UK and Europe. And so what time is that going to be your time if it's 1:30? Is that 9:30 at night?
9:30 for me. Unfortunately for Australia, that means that, for example, for Mark, we're talking 6:30 in the morning. So quite an early start for Mark there, But
I know that church the pastor did everything he possibly could to accommodate, and they had been starting to YouTube stream, so that's nice. They got the channel set up, and hope we get a really good turnout for that. I know we will, and I don't want to say I'm looking forward to it. How would you put it?
Yeah, I know what you mean. It's not something you look forward to, but on the other hand, it's an important occasion, and then it's just a case of full steam ahead and trying to cover as many of these cases delving into them. This Daniel Holtzclaw case.
Are you making some headway going through the documents? There's a lot of documents.
There are, yes. I've been completely snowed under at the moment, so I will start looking at that. Maybe with a little bit of guidance as to what particular parts to look at in particular.
One last question, I'll let you go.
Yeah, sure,
and we can do that. And you weren't even close to the line in this broadcast, but maybe next time you'll be over the line, Smokey. But I was looking something to look up. You come from, so there's an instrument known as is it a piano accordion?
Yes.
And your grandfather and your uncle brought the piano accordion to the UK. Is that right? Or popularized it?
Yes. My granddad, and originally it was his brother, my great uncle Nick. They were a variety hall act back in the 1930s, and they were certainly the biggest variety hall act at that time, doing what they did, which playing as duets, but play popular tunes of the day, things like the William Tell Overture, Under the Double Eagle. If it was popular in the day, they did it as a duet. And I mean, they were so successful that the main accordion manufacturers, Hohner, actually paid my granddad £2 a week just to gave him the accordion and paid him, to endorse.
He was sponsored, huh?
Yeah,
wow.
Yeah, that's right. Yeah. And I mean, £2 was more than what most people got paid a weekly
I was
wage.
interested in their, they had a very original name for their act. The Capaldi brothers.
That's right.
Who came up with that?
I'm not sure. They must have had like a think tank and batted around a few things,
But they were very busy, and then you were starting to say who took over for your uncle. Your uncle left the act, or?
Yes, my uncle married his wife, and they focused more on him playing accordion and her singing. And so a fellow by the surname of Di Tommaso, who was one of my granddad's advanced pupils, he then became the second part of the Capaldi brothers. And my granddad met my nan because she was one of the dancing girls, what they call the Tiller girls in the entertainment, in the variety hall act. So that was I would have liked to have met your granddad. Oh, it was something else. He was. I mean, of course, just before the war broke out in 1939, my granddad was in the process of talking to Hohners about opening a Capaldi music shop in all the major cities in the UK. And but for the war, he would have been they would have done this. They, backed by Hohners, there would have been a Capaldi's in, every major shop. But of course, the war broke out, so even stuff that my granddad was playing, like that Sousa March, Under the Double Eagle, he had to stop doing that because people thought there was some sort of Nazi connection. People Italian background living in UK when the war broke out, they were looked upon very suspiciously. But in actual fact, one of the things my granddad did was he diversified, bought himself a tipper lorry, and helped to build a US Air Force base just outside of Evesham. No kidding. Yeah, he drove a tipper lorry, just carrying aggregate and all that kind of stuff to and from the site. They were building this American air base. So in the U.S., a lot of celebrities, musicians, entertainers joined the armed forces, but they were in a special unit that went around and entertained the troops. Did your
grandfather and your uncle, were they in the service during the war, and did they?
Not that I'm aware of. As I say, I think it was more a case of, I say, granddad got his got this tipper lorry. I think also it must have been around about that time. Obviously, synonymous with Capaldi's were ice cream, and certainly in Worcestershire, which is where Evesham is. My granddad apparently was the largest ice cream manufacturer in Worcestershire. So no, there were, as you say, there were special sort of sections of the army, wasn't there, that was specifically put together to go and entertain the troops. Well,
I know in the UK, I mean, it was all hands on deck. So if you weren't in the service, you might be at the cliffs of Dover with a pair of binoculars looking for airplanes, and then they had this network of how you would sound the alarm, and that would get all the way to the air bases. But they had this entire civilian observation crew. The war effort in the UK was a very, very unified effort. It was in the US too, but it was more in terms of manufacturing and getting material out until we got into the war after Pearl Harbor. But it's fascinating how they got everyone on that country. I guess really Churchill did his inspirational speeches. But I guess I'll say it's goodbye from me.
And it's goodbye from Travis. Thank you very much for coming on. We'll speak again soon, hopefully. Enjoy the rest of your morning. And bye to everybody. Thank you for tuning in. Bye for now.